This is Barry Zelma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the difference between the word domicile and the word residence as it is used in insurance contracts and insurance claims. Insurance companies often see disputes relating to the terms domicile and residence. It is important, therefore, that everyone in the business of insurance must understand the meaning and application of the terms to insurance claims and how they relate to individuals and corporations that are insured or are insurers. Although a person may have more than one residence, he or she may only have one domicile at any one time. Domicile is established initially at birth and is presumed to continue in the same place, absent sufficient evidence of a change. To effect a change of domicile, two things are indispensable. First, residence in a new domicile, and second, the intention to remain there. If a person is domiciled in a particular location, that location remains his domicile whenever he is absent, so long as he has the intention of returning. In determining domicile, courts consider factors including voting registration, employment, current residence, location of real and personal property, location of a spouse and family, a driver's license, automobile registration, tax payments and addresses, and location of a person's bank account and physician. Residency does not necessarily equate to domicile, which is the definition of citizenship for diversity jurisdictions and purposes. With regard to an accident, domicile is usually determined by the following. 1. The state where the policy was formed and issued. 2. The residence and domicile of the parties to the accident. 3. The residence and domicile of the parties to the insurance contract. 4. The state where each vehicle was principally garaged or registered. 5. The state where treatment for resulting injuries was delivered. And 6. The reasons why each party and vehicle were in the state where the accident occurred. The role of the domicile of a corporate insured should be a dominant fact when dealing with the appropriate interpretation of an insurance contract. For example, according to Illinois law, a corporation is always domiciled in its state of incorporation. Whenever a court is asked to determine a person or corporation's domicile, determination is generally considered a question of fact. However, where the underlying material facts are not in dispute, the determination of a domicile is a question of law for the trial court. Michigan courts have defined domicile to mean the place where a person has his true, fixed, permanent home and principal establishment, and to which, whenever he is absent, he has the intention of returning. A person may only have one domicile. However, a person can have multiple residences. Michigan courts, as do most states, apply a multi-factor test in which no one factor is determinative to determine domicile. The Michigan Supreme Court articulated 4 factors to be considered when determining a person's domicile. 1. The subjective or declared intent of the person of remaining, either permanently or for an indefinite or unlimited length of time, in the place he contends is his domicile or household. 2. The formality or informality of the relationship between the person and the members of the household. 3. Whether the place where the person lives is in the same house, within the same curtilage, or upon the same premises. And 4. The existence of another place of lodging by the person alleging residence or domicile in the whole household. The New York appellate divisions have similarly repeatedly recognized that where the insured risk is scattered throughout multiple states, New York courts deem the risk to be located principally in one state, namely, in the state of the insured's domicile at the time the policy was issued, and thus have held that the state of the insured's domicile should be regarded as a proxy for the principal location of the insured risk. New York courts have noted that the state of the insured's domicile is a fact known to the parties at the time of contracting, and application of the law of that state is most likely to conform to their expectations. In Michigan, the No-Fault Act does not define the term domicile. The unambiguous language of the no-fault statute simply states that a personal protection insurance policy applies to accidental bodily injury to the person named in the policy, the person's spouse, and a relative of either domiciled in the same household. Residence in fact, coupled with the purpose to make the place of residence one's home, are essential elements of domicile. On the other hand, the controlling factor in determining residency is intent, as evidenced primarily by the acts of the person whose residence is questioned. In the context of automobile exclusions, residence is determined on a case-by-case basis, using factors such as intent and relative permanence. For example, in Holland versus Trinity Healthcare Corp., a 2010 decision of the Michigan Court of Appeal, the court defined the term reside as to dwell permanently or for a considerable time to live. In doing so, the court expressly explained that the definition of reside is not synonymous with the legal definition of domicile, which may have a more technical meaning than intended in the home insurance context under the policy language at issue. The term reside requires that the insured actually live at the property. A person, however, can have a residence that is not his or her domicile, because domicile and residence are usually in the same place. They are frequently used as if they have the same meaning. Domicile, however, means living in a location with intent to make it a fixed and permanent home, while residence simply requires bodily presence as an inhabitant in a given place. Thus, a person can have multiple residences, but can only have one domicile. The law ascribes a domicile to every person, and no person can be without one. Residence usually just means bodily presence as an inhabitant in a given place. Residency may require actual physical presence on a permanent basis or physical presence on a temporary basis with a primary residence elsewhere. The words residence and resident have no fixed meaning applicable to all cases, but are used in different and various senses depending upon the subject matter compelling a court to conclude that the term is ambiguous and needs to be interpreted in favor of the insured. However, everyone should understand that in certain climates, like residents of Vermont in the winter might go down to a second residence in Florida to escape the cold. People in Britain will spend summers in Spain. Both are residences, but the one you come back to always is the domicile. If an insurance policy does not include a choice of law provision, then the court considers the following factors in determining which jurisdictions apply with regard to a corporation. 1. The location of the subject matter. 2. The place of delivery of the insurance policy. 3. The domicile of the insured or of the insurer. 4. The place of the last act to give rise to a valid insurance policy. And 5. The place of performance or other place bearing a rational relationship to the general insurance policy. When a liability insurance policy covers risks in multiple states, some states use the state of the insured's domicile as a proxy for the principal location of the insured risk. However, other states find that the principal location of the insured risk may be in more than one state or location. Where a policy covers risks in multiple states, the risk of each individual state is to be treated as though it were insured by a separate policy, and the validity of each of the rights under the multiple risk policy as to this risk are to be governed by the law of that state. Where nationwide coverage is provided, the policy's legitimate expectation is that the site of the insured risk is more significant than the insurer's residence or the place of negotiation. When a larger insurer issues a policy to apply nationwide, it has no legitimate expectation that the law of its residence will apply in other states. This video was adapted from an article in my blog, Zalma on Insurance, which is available on the internet for free. If you found the video to be of use to you, please refer it to your colleagues. It's free. And please subscribe to my blog, to my YouTube channel, and to my Rumble channel so you can learn about future videos and future blog postings. Tomorrow I will be posting the rest of the article dealing with the requirement for an insured to actually reside at the residence premises. Thank you for your attention.